Swayam Prabha. Digital India. Educated India.
Welcome to all the learners. So, we have started discussing on renewable energy, what are the laws related to it, what are the policies related to renewable energy, how the Electricity Act deals with the issues of renewable energy. Carrying the clue from the last session, now let us look at some of the significant interventions made to promote renewable under the Electricity Act. So, in today's session, we will be discussing about renewable purchase obligation, we will be discussing about feed-in tariff, and we will also discuss about renewable energy certificates, and we will just look at some cases to understand that how the court has dwelled upon the issue of the promotion of renewable energy. When you look at the Electricity Act, as I have discussed in the last session, that the State Regulatory Commission has been specifically authorized to identify the obligation, to put up an obligation on the licensee to procure certain percentage of the requirement from renewables. And in that perspective, you would find that two specific instruments have been brought into notification by the Regulatory Commission. One is renewable purchase obligation and other is feed-in tariff. Now, renewable purchase obligation and feed-in tariff is about encouraging the developer to invest in renewable and assuring a market for them. That is what the design promises. Renewable energy certificate is a sort of creativity to promote renewable in a form which can be tradable without buying and selling of electricity. Where there is an obligation, but there is no electricity available, or the procurement is more than the obligation, then how to enjoy leverage upon the same. REC is a mechanism suggested for enjoying the dividend on the premium paid. Feed-in tariff and renewable energy certificate, they are mutually exclusive because of the very fact that in one case there is a generation happening and that is being sold. In other case, there is no generation and there is a notional consumption taking place. So, investor can choose either route for investment. Either one can install a generating unit and then get the fixed feed-in tariff, or one can invest and get the renewable energy certificate and trade it in the power exchange. So, buyer can meet renewable energy purchase obligation by both the means. So, it can either go for feed-in tariff or it can go for instrument. Now, let us look at what is renewable purchase obligation. As I stressed on section 86 and as I said that how renewable purchase obligation enjoys the legal status, because the State Commission has been entrusted with the task. If you look at the language, if the very subheading of the section of the section says functions of the commission. So, they have the task entrusted upon them, and in pursuant to the same, good number of state regulatory commissions, they have come up with the renewable purchase obligation. And what is renewable purchase obligation? It says that the regulatory commission specifies that the obligated entities are having a bounden duty to procure certain percentage of electricity from the renewable generators. Bounden duty. So, if their requirement is 1 megawatt, if distribution licenses requirement is 1 megawatt, and if it has been said that 10% of the requirement has to be met, then the 10% licensee has a responsibility to get that 10% from renewable sources. That is what is the duty which is being imposed. And who are obligated entities? It says obligated entities are distribution companies, open access consumers and captive power producers. It is not only distribution companies which are obligated entities, even open access consumers, they also do have the responsibility to meet RPOs. And RPO is to be determined at the state level by the regulatory commissions. Though there is an attempt made, which I have discussed earlier, that how the central government is now proposing that RPO is to be determined or to be aligned on the lines of tariff policy which the central government formulates. It is to be seen that how this suggestion is going to get received by the state governments. Now, RPO is being designed with a very idea to create demand and address the risk which is being posed in the investment on this sector. So, here what RPO is doing, RPO is compelling the consumer, compelling the distribution licensees that because there is generation happening from renewable, you have a duty to buy it. One may argue that this may not be in complete compliance with the idea of free market, where you give the choices, but then it can very well be justified by advocating the cause of environment. So, there is a mandate to purchase power, and what this mandate is doing? This mandate is ensuring that what is being generated, there is a demand for the same. So, RPO is in a way a mechanism to encourage demand side of renewable energy segment, demand side of the renewable energy. The distribution licensee cannot run away from the responsibility, it has to procure. And National Tariff Policy of 2016 says that the solar purchase obligation should be at 8% in energy terms by 2022, because renewable purchase obligation generally categorized based on solar energy and non-solar energy. And because it is an obligation under the law, it is not difficult to imagine that non-compliance of the legal mandate would attract the penalty, and that is what precisely is being provided also. Now, it is entirely a different story that how the regulatory commission, the state regulatory commission is imposing penalty on DISCOMs for non-compliance. Because please do take note of the fact that state DISCOMs are still working under the control of the government, and therefore, they do have a responsibility to address or cater to the interest which government indirectly presents before them. And that way compliance is not very successful, it is not up to mark. But legally speaking, it suggests that there has to be penalty for the same. When, as I said, that this is generally the state which identifies the RPO, Kerala Regulatory Commission has set the lowest RPO, 6.6 is the RPO fixed by Kerala Regulatory Commission. Highest one, when you look at Himachal and Rajasthan Regulatory Commission, they have fixed the highest one, and that is 21% of the total procurement. You would find that Ministry of New and Renewable Energy maintains a portal for RPO, and you would find a complete detail there. A national portal for RPO is maintained there, that what is the performance of the state, what percentage the state has identified. Now, there is a regulation also for feed-in tariff, that is getting its legal approval from the language of section 61, as I discussed, where it says that while formulating the guidelines on tariff, the promotion of renewable sector has to be kept in mind, and perhaps in pursuant to the same, the very regulation of feed-in tariff has come into existence. Now, renewable purchase obligation is contributing on demand side, feed-in tariff is contributing on supply side, because in this case the generator is being encouraged to generate from renewable sources and to get a fixed tariff as determined by the regulatory commission. And generally it has been said that feed-in tariff is fixed for longer duration. So, you can very well appreciate this, that investor would get the confidence to come and invest in this sector, because there would be certainty in terms of getting the revenue. A long-term power purchase agreement with a defined tariff, and also the regulatory commission approving, acknowledging must run status on the lines of conventional thermal power. Feed-in tariff was initially to be determined on the basis of cost plus approach, where it is to be seen that what is the cost of the technology which is being involved, and then to look at the operational factors, the maintenance factors, cost plus approach, so that the investor would get the return. Now it is being encouraged that let the buying and selling happen on the basis of competitive bidding, and we have learned from the experiences based on competitive bidding that it guarantees better pricing to the consumers. We have read that in recent past the tariff has come down, it is lesser than what is there for the conventional sources. Now, what is the key feature for feed-in tariff? It says that a guaranteed payment of fixed price, guaranteed payment. That is why this is in a way communicating to the investor that you will get the return on your investment. And additionally, it says that you will also get a preference in grid access and dispatch of electricity from renewable energies. All these measures are needed. All these measures are needed for promoting renewables in order to make it competitive and in order to also minimize the dependence on import of fuels. Now, feed-in tariff renewable purchase obligation is all about generating electricity. Renewable energy certificate presents a mechanism where there is no generation happening, but there is a trading happening, which is supporting the growth of renewable sector. So, this is a mechanism which has been suggested. What is the mechanism? That you buy this certificate and then trade it. Trade it, who shall be interested in that trade? The one who is not meeting the renewable purchase obligation, because if obligation is not being met, penalty is there, and there may be a possibility that renewable source of energy is not available in that part of state or in that geographical location, and instead of getting electricity from far flung places, it is better to buy REC. In that process, the obligated entities would meet the obligation, would meet the requirement of RPO, and the renewable will also get necessary push. So, that is what is the benefit. So, mechanism suggested is that the investor could set up a plant and sell the electricity component. So, investor is asked to set up the plan, and then a mechanism has been designed so that generated electricity is one component to be sold in the power market, and other is the green attribute, which is not about generated electricity, which is about contributing in the energy mix. So, that is also to be traded. So, to address the mismatch between availability, there is no availability, but then there is a requirement to meet RPO. How to do that? REC is a solution for the same. What is the value which is given? It says one renewable energy certificate would be equivalent to 1 megawatt hour. That is what it says. And then renewable energy certificate, as in the case of renewable power purchase obligation, categorized between solar and non-solar. Even in the REC, it has been said that let it get. And further it says that solar RECs are to be issued to eligible entities who generates who is eligible to generate solar energy. Likewise, other renewable energy certificate is to be given to those entities who are eligible to generate electricity from other renewable energy sources. So, who is eligible? The one who is eligible to issue REC is the one who has got the eligibility to generate, and then it is also said that REC is to be exchanged only in the power exchange, and as we have studied that we have two power exchanges which facilitates power trading. REC has not become very popular, but then there is a huge potential in the sea. Look at this phenomenal judgment, Hindustan Zinc versus Rajasthan Electricity Regulatory Commission, decided by the Supreme Court in 2015. Why it is phenomenal, revolutionary, remarkable, landmark? Because of the very reason that in this case captive power plants, they said that they do not have to follow the requirement of renewable purchase obligation. There is no mandate on them, because they are getting the electricity for their own use. So, where is the question of meeting the requirement of RPO? Now, this is something which has been argued and said that Rajasthan Electricity Regulatory Commission does not have necessary jurisdiction to provide a legal requirement to get RPO for captive power plants. They said captive power plant is being dealt under generation and it is been delicensed. So, where is the question of treating them at par with distribution licenses when it comes to fulfilling the obligation for RPOs? They are not distribution licenses, and ideally RPOs are meant for distribution licenses. Now, the matter went all the way to the Supreme Court, and Supreme Court said that RPO is not only about ensuring the return to the investor, it is more of fulfilling the larger public interest. And what is that larger public interest? That is clean environment. And the court has displayed the creativity and taken assistance from the constitutional values, constitutional provisions, 51 AG and Article 21. 51 AG, which talks about improvement of environment, state shall make necessary endeavor to improve environment, and 21 which talks about right to life and liberty, where 21 has been expanded to include right to clean environment, right to health. So, the court, with the support of these constitutional provisions, have said that RPO is for a larger purpose, and therefore, the regulatory commission is not wrong in imposing an obligation on captive power plant and make them equivalent to distribution licenses for the purpose of meeting this RPO. That is what the court has said. So, look at the way the court has taken the support of rights based argument for promoting renewables. That is what is the significance, that is what is the highlight of this case. Now, this is another case which deals with a proposal to reduce the tariff with a retrospective date by the government. Renew Power Limited versus State of Andhra Pradesh, 2019. Andhra government suggested that the tariff fixed through competitive bidding is on a higher side, and DISCOMs are not in a position to pay the same. When the tariff was fixed through a transparent and fair process and PPA was agreed or entered, 2014 Andhra government invited the bid, developers shown the interest and established the power plant based on solar and wind, and they started generating also, they started supplying the electricity, but then they are not being paid by the DISCOMs, and later on the state government has instructed to reduce the price, reduce the tariff. Now, this was contested by the developers. They said that the tariff was being determined based on agreement, and how can the state government now interfere and instruct to reduce the same. Matter went to the High Court. High Court categorically said that government is not a party to the power purchase agreement, government is a third party, and unilaterally there cannot be any alteration on the terms of agreement. On the argument advanced by the government of invoking power under section 108, which enables the government to give necessary directions in public interest, the Andhra Pradesh High Court turned down this argument and said that there is no public interest involved here, because you have to also look at the sanctity of the contract entered between the parties. Now, this matter is pending before the Supreme Court. It would be interesting to see that how the Supreme Court addresses the issue. Why? Because the matter involves sanctity of the power purchase agreement entered between the developer and the DISCOMs. Why? Because the tariff determined through that agreement is apparently on a higher side, which ultimately not catering to the interest of the consumers. So, it would be interesting to see that how the Supreme Court decides on it, whether Supreme Court goes by the sanctity of the contract or court comes up with a kind of formula to balance the competing interest. So, this is on renewable purchase obligation, feed-in tariff, renewable energy certificates. Thank you very much. These are the references for the session.